Now, turning to our program, please welcome past President Jim Barry, President of Barry Company, who will introduce today's speaker.
Thank you, President Beth. As our nation celebrates its semi-quincentennial, the program committee thought that it would be fitting to honor and commemorate this auspicious event at one of our Tuesday meetings with a speaker who could offer us thoughtful and learned reflections on the Declaration of Independence and its significance to our country. I think I can state rather confidently that there is no better person to deliver such remarks than the longtime Dean of Marquette Law School, Joe Kearney. Dean Kearney has served as Dean of the Law School since 2003, making him one of the longest-serving law school deans in the nation. He is only the 9th person to hold that position since 1908. He has been a member of the law faculty since 1997. Before coming to Marquette, Dean Kearney practiced law at Sidley and Austin in Chicago. Prior to that, he served as a law clerk to Judge Diarmid F.O. Scanlon of the U.S. Court of Appeals for the Ninth Circuit and for Justice Antonin Scalia on the United States Supreme Court. He is a graduate of Yale College and Harvard Law School. Dean Kearney is the author of numerous articles and books and continues to teach a variety of courses in the law school. Under his leadership, the law school moved into its magnificent new home, Eckstein Hall, in 2010. As you all know, Marquette Law School plays an extraordinarily important role in the Milwaukee community in shaping new leaders, producing important data, such as the Marquette Law School poll, and providing a venue for important discussions on a wide range of legal, public policy, and other important issues. Leading that institution is Dean Joe Kearney, who is an old friend and is certainly one of the glittering gems of our Milwaukee community. Let's give him a warm Rotary welcome.
Good afternoon, and thank you, Jim, for your exceptionally kind introduction. It was also bold. I made a decision early on in preparing for today that I would not approach the word semi-quincentennial. And yet I would fall short of your example if I did not say it thus. And I will have the good judgment not to give it a second try also. This really is a humbling invitation for two reasons in particular. First, we could save time by my simply reading aloud to you the full Declaration of Independence. We would begin with the first sentence. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. The entire effort would scarcely require 12 minutes, about half the time of my remarks, and we would all be sure to learn something. Such a public reading of the Declaration of Independence would also be in keeping with an American civic tradition of sorts, if not quite so widespread today as once was the case. Yet, tempting though that purely oratorical approach would be, I have taken it not to be consistent with my charge. The second reason for my humility is that this 250th anniversary has occasioned a substantial number of books exploring the birth of our nation generally and the Declaration more specifically. I am not among the authors. I make this second point to persuade you not that the organizers of this program made a mistake in inviting me, but rather that much very good learning is available in longer form about 1776 and the origins, meaning, and legacy of the Declaration of Independence is available to you at Boswell Books and elsewhere. Yet I believe myself to be in a position to make some suggestions as to the place of the Declaration in our legal and broader political system, and the way in which it variously is both a statement of founding principles and an exquisite piece of lawyering in its own right. Do let me begin with an important point. The Declaration of Independence is not itself law, as we Americans today tend to understand the concept, as a set of mandatory instructions or prohibitions. To give you a quick feel for this, we did a bit of research. Since statehood, the Wisconsin Supreme Court, or a justice of the court, has invoked the Declaration of Independence in only some 36 judicial writings over the past 178 years. To be sure, the Wisconsin Constitution begins with a Declaration of Rights, the first sentence of which borrows from the Declaration of Independence, but the very scarcity of references is a telling point with respect to what the Declaration is or is not. It is not law as we experience it every day, or as our courts, state or federal, understand their work to involve. Yet no one should doubt the centrality of the Declaration to the American experiment and experience. The Declaration's second sentence speaks of rights even more directly than with the subsequent 1787 Constitution, before the first 10 amendments, which we have come to know as the Bill of Rights. While I do not plan intermittently to smuggle in a reading of the entire Declaration, here is that second sentence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, devising their just powers from the consent of the governed, that whenever any form of government becomes destructive of those ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness. The title of a recent book by Walter Isaacson has proclaimed this the greatest sentence ever written. The superlative in particular is a matter of opinion and taste, but the power of the sentence is plain. Over time, we have come to emphasize rather more and to develop the first portion of this sentence concerning equality than, say, the latter, which asserts the right of the people to alter or to abolish the government. Indeed, the Declaration's allusion to equality helped stir the American conscience in the 19th century in such a way that we eventually confronted and abolished the institution that had blighted and belied American ideals from the beginning. I refer, of course, to slavery. Certainly, the 1787 Constitution was of quite limited help in any direct sense. Consider Frederick Douglass's famous 1852 speech to the Rochester Ladies' Anti-Slavery Society. What to the slave is the 4th of July? In this searing indictment of the gross injustice and cruelty of slavery, Douglass nominally relied on the Constitution, but it was the great principles of the Declaration of Independence that gave him true power. Liberty and equality are often seen as in tension with one another, and to my mind, one of the greatest accomplishments of the Declaration of Independence is that it speaks so comfortably and enduringly to both concepts and helps us in part to reconcile them, as Douglass's effort sought to require. In fact, the Declaration's early, almost prefatory reference to equality is scarcely central to the document's essential logic, but the assertion was and is there, available to Douglass and all for such use and value as can be made of it. Such a summary or account as I have given so far may give the misimpression that the Declaration of Independence, being not law for us, rather is simply a statement of political philosophy. In fact, the Declaration is an intensely practical document. Not only does it do something, but it grounds its action in particulars, and rather quickly and extensively. After only one more sentence, beyond what we have already read together, the Declaration turns to what might be called a Bill of Particulars against King George III, detailing the long train of abuses and usurpations that formed or sought to form the establishment of an absolute tyranny over these states. To prove this, the Declaration says, "Let facts be submitted to a candid world." There then follows an interesting catalog, which forms the bulk of the document. Let me give 3 of the 27 or so grievances, as they are often called. The he refers to the king. He has dissolved representative houses repeatedly for opposing with manly firmness his invasions on the rights of the people. He has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. He has affected to render the military independent of and superior to the civil power. It is hard to stop there, particularly with other powerful indictments, such as he has plundered our seas, ravaged our coasts, burnt our towns, and destroyed the lives of our people. My interest is to note, if I may, that this is good lawyering. It is a fine thing, eloquently to have articulated governing principles, as already summarized, even if the best that one can do in terms of authority has been to say that he is relying on truths that are self-evident. Please know, by the way, that I say that wryly. Thomas Jefferson's original draft had said, "We hold these truths to be sacred and undeniable." It was Benjamin Franklin who, in the editing process, made the felicitous revision to describe these truths as self-evident. Yet a legal precept standing alone isn't enough. A good lawyer must marshal the facts that, together with the law, point toward the judgment in one's favor. So we have been given the law or legal precepts in a few elegant opening sentences, and then, in some considerable detail, the facts. One might think us to be ready for the judgment, the decree, if you will, or at least the application of the law to the facts. Yet the signers of the Declaration are careful next to say that they have exhausted their remedies, to use a familiar phrase in the modern law. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. That is, by the way, the fourth and final reference to a tyrant or tyranny in the Declaration. This was an important classical concept that John Locke, among others, had further developed in the late 17th century to explain when the executive's misconduct makes the people's rebellion or an appeal to heaven appropriate. Yet let me complete the point about the declarations being a last resort. Nor have we been wanting in attentions to our British brethren. We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our emigration and settlement here. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They, too, have been deaf to the voice of justice and of consanguinity. We must, therefore, acquiesce in the necessity which denounces our separation and hold them, as we hold the rest of mankind, enemies in war, in peace, friends. To my mind, This is a political rather than a legal point, even in the context of the Declaration itself. That is not to denigrate it. We sometimes use the word politics to suggest something common, even base. The former, it certainly is, or should be, but mostly unapologetically so. Politics is nothing more, or more pertinently here, nothing less, than the ordering of relations among individuals who live in the same community. For example, when Aristotle referred to man as a political animal, as it is often translated, the basis of the adjective in his phrase, politikon ha anthropos zoon, is the noun polis, or city-state. This is why the phrase can be equally well translated that man is a social animal. But my focus should be on the 18th century, not more than 2 millennia earlier, and it is fine rhetoric to express an interest in a good future relationship with the British people beyond the king. This certainly supported the reminder to them that they had been, well, on notice, as we might say, and a reassurance that there is no inherent enmity, but a long-term interest in friendship. Let me get to the declaring clause itself. We, therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by authority of the good people of these colonies, solemnly declare and publish that these united colonies are, and of right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do. This is a magnificently stated sentence. General Congress, Supreme Judge of the world, solemnly declare and publish, etc. It is also an intensely practical one. It announces to the world at large, especially other nations, our arrival as independent states and some of the rights appurtenant thereto. Such an announcement would be important, given that the new country was engrossed in a war with the British that was not going well at the time. Indeed, it had been going better earlier that same year, when General George Washington had caused General William Howe to withdraw the British forces from Boston and decamp to Nova Scotia. In June 1776, however, the British had begun to sail from there to New York. It would take some weeks or months for the British, under the command of Howe's older brother, Admiral Richard Howe, to assemble one of the largest naval fleets the world had ever known, but it was already clear that the action was coming a lot closer to Philadelphia and the Second Continental Congress. It was in this general context that Jefferson and the other members of the Committee of Five, charged with drafting a Proclamation of Independence, John Adams, Benjamin Franklin, Robert Livingston, and Roger Sherman, undertook their work. This was one of 3 concurrent committees formed to build a case for the Lee Resolution, pending before the Congress, whose other 2 parts, and thus other 2 committees, concerned taking effectual measures for forming foreign alliances and preparing a plan of a confederation. In other words, one needed a Declaration of Independence in order to be in a position to treat with other nations, in particular to seek their military and financial support, and to govern oneself. In a sense, such a declaration was just a formality, though a necessary one. The fact of a committee, of an editing process involving multiple people, is one of my own favorite facts about the Declaration. We often refer to the Declaration as Jefferson's handiwork, and he was unquestionably the principal author. Yet editing was involved, as we already noted in discussing the self-evident truths. Most of the editorial attention in the Second Continental Congress concerned the facts, that is, the grievances. We today have the liberty, perhaps even the responsibility, to regret one deletion in which Jefferson, whom we famously remember as a slave owner, excoriated the British slave trade. But its exclusion may have been not only necessary to keep South Carolina and Georgia on board, but almost essential to avoid immediately discrediting or too obviously belying the claim of equality. Nor would any of us suggest that a document referring to the merciless Indian savages reflects all of our best ideals as Americans. Yet for my point of focus here, without doubting Jefferson's centrality in the draftsmanship or its falling short in some respects, the Declaration was a better document for not having been the product of only one person. My own experience on somewhat less important documents reflects the value of such an approach time and again. Beyond its immediate practical value, the Declaration of Independence has an enduring value as a cultural document. The Declaration establishes us as a creedal nation, it has been said, one that belongs to newcomers who embrace its defining principles and ideals no less than to those whose direct ancestors were present at the creation or who are of a particular race, religion, or ethnicity. This is a good thing for me, all of whose forebears were nowhere near Philadelphia or even North America in the late 18th century. To be sure, being all in Ireland at the time, my people would not have been outflanked in terms of righteous grievances against the King of Great Britain. None of them was here at the time of the Civil War either. Yet all of them, and thus I, benefited upon their immigrating to the United States from not just the laws that sufficiently enabled them to become citizens, but from the culture that sufficiently, if imperfectly, welcomed them. Even in our darker times, we have had available to read not only the text of the document that establishes the government of the United States of America, the Constitution, but its context, in particular, the declaration that preceded it. To speak of text and context is not very poetic. Thus, I am rather more drawn to a metaphor from Abraham Lincoln, which I am grateful to Jim Barry for having noted to me. You need no tutorial on the circumstances in which the Union and Lincoln found themselves as he journeyed from Springfield, Illinois, to Washington, D.C. in February 1861 to take the oath of office as the 16th President of the United States. His notes and jottings have helped one modern student of Lincoln, Harold Holzer, capture Lincoln's thinking. Here's Holzer, liberally quoting Lincoln's personal notes. In a fragment crafted before leaving his hometown, Lincoln imagined that the nation might yet be saved precisely because it had been inspirited by a declaration of principles and then protected by a constitution of laws. Without the aspirational expressions in the Declaration, he opined to himself, we could not, I think, have secured our free government and consequent prosperity. Echoing the book of Proverbs, among the proof that Lincoln considered the Declaration equivalent to American scripture, he described Jefferson's gem as the word, fitly spoken, which has proved an apple of gold to us. The Union and the Constitution, he perpetuated the biblical metaphor, are the picture of silver subsequently framed around it. The picture was made for the apple, not the apple for the picture. So let us act that neither picture or apple shall ever be blurred or bruised or broken. Then, stopping in Philadelphia and now speaking publicly at Independence Hall on Washington's birthday in 1861, Lincoln made the general point without the apple metaphor. Here's Holzer again, mostly quoting Lincoln. I have never had a feeling politically that did not spring from the sentiments embodied in the Declaration of Independence, Lincoln proudly admitted to the great cheering from the audience filling the shrine where the document had been signed. It was not the mere matter of the separation of the colonies from the motherland, but something in that declaration giving liberty, not alone to the people of this country, but hope to the world for all future time. It was that which gave the promise that in due time, the weights should be lifted from the shoulders of all men and that all should have an equal chance. Lincoln was, of course, an exceptional lawyer, and his skills in that regard and other respects helped save the Union. Yet he ranked the Constitution behind the Declaration of Independence in importance to the success of the United States, not only in the 18th century, but in the face of the greatest crisis our nation has ever faced, a civil war in the mid-19th. Time permitting, as it does not, we would adduce other examples, including women's rights and women's suffrage into the 20th century, and the civil rights movement of the 1960s, where the Declaration of Independence and its ideals, as we had come to understand and refine them, made a powerful positive contribution to the course of events. Candor would require us to acknowledge, with dismay, some contrary invocations as well. To conclude, let no one doubt that the political bands, in Jefferson's phrase, or the social connections, if you prefer, that we have with one another, these aspects of our culture make an extraordinary contribution to our survival and growth. This is why, with apologies to Mr. Isaacson, it is the last sentence of the Declaration that is my own favorite. And for the support of this Declaration, with a firm reliance on the protection of divine providence, we mutually pledge to one another our lives, our fortunes, and our sacred honor. Its very rhetoric is elegant. What an accomplishment to write a phrase that begins with a mutual pledge of our lives and yet does not turn anticlimactic. Yet its substance, too, is essential. It may look to our Constitution and our other laws, including not least the courts that they create, to preserve our rights. Yet we must ultimately rely on ourselves and one another together to preserve the American Republic. To return finally to the Declaration's first sentence, we must be one people. And as one people, we must be confident in certain basic propositions, as, most obviously, in declaring independence. Yet let me submit that the Declaration also reflects the value of our tolerating not only difference, but also some ambiguity, irresolution, and even avoidance on certain points, or at least at certain moments. The Declaration of Independence's precise attitude toward equality, toward slavery, toward some underlying questions of theology or philosophy is hard to pin down. Some of these questions could be deferred only briefly, such as the form of government, others for a longer time, into the 19th century, and still others remain our society's work today. While the legislatures or other Republican devices, for example, school boards, should continue as central venues for our unfolding work as a people, so too should be gathering places like this, where we come together with others beyond our tribes of religion, political party, or the like, where we gather as Americans. In that regard, I want to say that I can think of no place where I would have been gladder to speak on this topic than the Rotary Club of Milwaukee. Kudos to you and other such civic groups for promoting and helping continue to secure the premise and promise that inspired and animate American independence. Thank you.
Thank you, Dean Kearney. Brought me back to college, and your skills and your education is obvious. We're going to welcome questions now, and remember, a good question is one that asks his opinion while refraining from sharing your own. Who's first? Smoller, you're second.
Hi, my name is Amy Turner. I have a question about something I think you were getting at towards the end around questions of theology. And given Jefferson's deism and the general founding fathers' view of separation in church and state, how do you see that sort of playing out now with increased efforts to, I won't state my opinion, as religion is showing up in various aspects of law or efforts to make law? How do you sort of see that original founding father vision of a separation of church and state with our current legal system?
Right. I am saved perhaps by my having made clear that the Declaration of Independence itself is not law. At the same time, you are right that we can see Jefferson and his attitudes towards religion in the Declaration of Independence. I would say that that is an aspect of the Declaration where it is not just Jefferson. And so the references to God and divine providence very much draw also on more conventional religious views at the time, such as those of John Adams. It is, I think, without question, the case that the Declaration of Independence does emerge from a particular Judeo-Christian ethic and philosophy. This is why the connections with Locke are so important, the effort to demonstrate that the appeal to heaven is appropriate in the circumstances of a tyrant. It is the Constitution, in terms of the First Amendment in particular, that particularly constrains some aspects of what legislators can do now in the context that might come close to establishing religion or might come close to violating free exercise. But I think that the ambiguity with respect to the nature of the underlying religious views, though certainly Christian in nature to an extent, gets toward the point I was making at the end, which is some value in the ambiguity. I don't think we're going to learn too much from the Declaration itself that will save us from debating and deciding some of those questions on other bases. I hope that's responsive.
Jeff Smiller, thank you for a remarkable speech. You said in the end that the Declaration is a cultural document, and given your colleague Paul Kahn at Yale, the cultural study of law, he speaks to how our laws, the Constitution and so forth, came from culture. In terms of what happened before the Declaration of Independence was signed, they came up with the Bill of Particulars and expressed frustration about no remedies available. Given that background, do you believe, what is your view of today's society and its ability to deal with the fractions you've talked about in the context of the Declaration and satisfaction or dissatisfaction with the United States of America as an institution?
I'm bullish on the United States of America. It seems to me that if we can make it as a nation through the Civil War and the aftermath, we can make it as a nation through the challenges that we face in the 21st century. It is a challenge for us that we are fraying in some respects with respect to a common culture, and the very example of a diminishing religiosity among the people is an aspect of that. It is a different society from the one that drafted not only the Declaration, but also the Constitution and the amendments. But I think that we can do it, and I think we are doing it. It will result occasionally in policies that one or another of us doesn't like. All of us dislike one policy or another at any given time, but an acceptance, for example, of the primary role of the legislature, an acceptance as well that there's a role for the executive, and a realization that some hard questions, whether we call them balls or strikes or not, are going to be made by judges, some of them with life tenure. You know, those are all things that I think that the American people continue to accept, and I think we're going to do just fine.
Thank you for your speech today. As Americans, we of course know about the Declaration of Independence. As a scholar, I'd like to ask you, are there other declarations from other countries that might be worthy of us either reading or might have influenced other legal foundations?
So I disclaim the title of scholar as much as you would like to assign it to me. I'm just an old country lawyer, as they used to say in the early 1970s, but I do appreciate the compliment and the question. It would seem not quite right here on July 14th, Bastille Day, to make no reference to the French Revolution and the various documents, the rights of man, and all that are associated with it to an extent. I prefer our revolution, not only because it's ours, but for other reasons as well. That was more radical in certain ways and more of a rupture with what came before. But, you know, certainly the document that has inspired other nations since the 18th century from the United States is, to an extent, not only the Declaration, but also the Constitution and the Bill of Rights. And there's so much to read out there that I think I last spoke to the Rotary Club 16 years ago. So maybe 16 years from now, Jim, I'll be good for a talk on that.
Hey, thanks for the presentation today. I was struck when you read the second sentence. I mean, there's kind of the famous part that we all hear and think about, and then there's the second part. It's, you know, the more we dissolve the government language. I wonder, given that sentence and kind of the early American experience with the Articles, do you think the founders would be surprised that we're still on the first Constitution and it's lasted this long?
That's a great question. I sort of think that, and I have not researched this, so there could be text on this out there that will disprove this, but I sort of think that James Madison had sufficient self-confidence that he would not be remotely surprised. Whether he would be discontent with the fact of amendments beyond the Bill of Rights, I don't know, but I don't think so. I think that there was a sense that they were building for the ages, a hope of that, and that would be my best initial answer.
Thank you. My name is Fred. I'm one of the minority, I think, in this room that participated in the much easier to pronounce bicentennial, which was 50 years ago. And I think that bodes well for our club, which has youth associated with the future of the club. Do you see the same thing in our nation? Do you see people, young people, getting more involved, and how do we get them more involved in the founding documents and perpetuating the great nation?
Well, I do think that organizations such as Rotary are really important to that. We run the somewhat unlikely vehicle, Jim referred to it, of the Marquette Law School poll, and we did a national survey. We just released the results in the last week of June and the first week of July, which focused rather less on the typical horse race and rather more on what might be called social trends. And we had the 250th in mind. And I'll just give you, these are all public facts that are on the Marquette Law School poll website in the various releases. So we asked about attention to the 250th anniversary of the Declaration, and the poll finds that only 26% of Americans have read or heard a lot about the 250th anniversary. It was coming up then on July 4th. Another 57% say that they have heard some about the semi-quincentennial, while 17% reported having heard nothing at all. But the reason I bring this up is that while there was no Marquette Law School poll in 1976, there was polling at the time on it, and in a Roper organization poll in June of 1976, 28% said that they were following news about the bicentennial rather closely. I recall that, the bicentennial. I'm with you in the minority, with 50% following casually and 22% paying no attention. So 26% now, 28% then. 57% now in terms of having heard some, 50% then. 17 having heard nothing now, 22 paying no attention then. So I do think that there is reason to be concerned about civic education, but I don't think that the data, and who would doubt the Marquette Law School poll, show any material difference in this one particular respect from 1976.
Last one, I guess, from Beth there.
Oh, and I so wanted to end with the Marquette Law School poll, but go ahead.
Sorry, well, maybe you can get to it as well. One
You
of my
might be
favorite-
surprised by my ability to smuggle it in. Go ahead.
One of my favorite sentences in the Constitution, or excuse me, Declaration, pardon me, is to prove this, let facts be submitted to a candid world. It's always been one of the things that struck me. Can you make any comments on the world's candidness today with all the different media and the consistency of the data you just cited from those two celebrations is interesting, but has there been any change in our candidness, do you believe?
Well, no change perhaps in the candidness, but perhaps greater doubt as to what is a fact, I'm sorry to say. And in fact, this does enable me to get the Marquette Law School poll back into this. I resisted the idea of a poll when we, in a rather unlikely move, recruited Mike Goucher to the law school some 20 years ago. But I learned from him and from Charles Franklin, whom we recruited from the political science department at the University of Wisconsin-Madison, that polls involve facts. They may be imperfectly measured. They may be off in one respect or another, but they involve facts. What is public opinion on some particular matter? And the only people without those facts were the public. Politicians poll all the time, as you would expect. They don't release the polls unless it especially suits them in a particular instance. I don't say that critically. And so I would say that an attention to facts and an attempt to establish certain facts that we do hold in common is an important, to say compliment doesn't really begin to get at it, an important counterpart to candor. Candor's great, but candor with respect to untruths is not good. So, thank you.